First Amendment cases are about the power. Who should have the power to tell individuals what to read, think, believe, or feel? I'd like to start with the Bill of Rights because it is the law that the government has to obey. Now, certainly, of course, the government has to obey the statutes that Congress passes as well, but this is our basic charter that defines the limits of how far government can go with respect to the individual. And because of that, I feel especially privileged that I've had an opportunity in my career to spend my time defending the Bill of Rights. Most Americans, no one in this room of course, but most Americans really sort of take it for granted, don't really think about how important it is until they have some event that reminds them that not everybody enjoys the privileges that we take as just breathing the air. My wife, a couple of years ago, was traveling in Iran. She's a bioethicist and was touring various places in the country and talking to doctors and going to conferences. And every now and then someone would ask her, "What does your husband do?" And she'd tell them. And invariably, that person would say, "Isn't that dangerous?" Well, no, not here. It's not dangerous to defend free expression. Well, actually, I have to take that back. There was a case I worked on a few years ago where we challenged the constitutionality of the FTC's do not call list for telemarketers. And after we, at the district court level, won an injunction in that case, the judge started getting death threats. So yeah, it can be dangerous, but he was safe after we lost on appeal. So we'll talk not just about the Bill of Rights, but more specifically about the First Amendment. And I think it makes sense to do that by actually focusing on the words of the First Amendment. 45 words. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Now you read that and you think, okay, this guy's a First Amendment lawyer. He must have the easiest job in the world. I mean, how hard is that to understand? No law. Hugo Black, as a justice, would frequently say, no law means no law. And so, we'll apply the First Amendment as it was intended. Although, Justice Black said that things like picketing were not protected by the First Amendment fully because they were speech plus. They were more than that. So it quickly becomes apparent that protecting the First Amendment doesn't mean that everything involving words is off limits for government regulation. Otherwise, you could go into a bank, hand the teller a note that says, "Give me all your money," and then you could argue, when the police haul you in, I was exercising my First Amendment rights. Well, no, it doesn't quite work that way. After you spend a little bit of time thinking about it or working with some of the cases, you realize that the First Amendment, the terms that we're talking about, the freedom of speech and the freedom of press, are terms of art that have been developed over years and defined, and the effort made to focus on exactly what they mean. Now, that has led to a lot of legal theorizing about what the framers intended when they wrote these words. Former Judge Robert Bork, for example, wrote famously in a 1971 Law Review article that the First Amendment really protects only that speech which is expressly political, which is rather unsatisfying if you think how limiting that would be. Former president of Amherst College, Alexander Michaeljohn, theorized that the First Amendment is an absolute, but again, only with respect to political speech. He later revised that view because he realized that it wasn't very workable, and he said that, well, political speech includes art, science, music, philosophy, all of those things that are required to make political speech meaningful, so it broadened it rather directly. But one of the things that I want to focus on tonight is the idea that many people will argue that the First Amendment limits start with speech that we consider speech to be of no value. This is an argument that we see recurring again and again, and a good example of that comes with Justice John Paul Stevens in actually his first decision as a Supreme Court justice, a case involving zoning of adult uses. Young versus American Mini Theaters in 1974. And in that case, he basically said, few of us would send our sons and daughters off to war to preserve a citizen's right to see specified sexual activities exhibited in theaters of our choice. Now, that, to him, was sort of a limit of the First Amendment. That was part of a plurality, that's easy for you to say, a plurality decision, meaning it wasn't the decision of the court, but that sentiment is something that you see expressed again and again. Although, interestingly, Justice Potter Stewart, who famously wrote, "I may not be able to intelligibly define obscenity, but I know it when I see it," disagreed with that sentiment and wrote in a dissenting opinion that if the First Amendment protects no more than what we would send people off to defend, then it is circumscribed by public opinion, and he wasn't going to sign on to that sentiment. We see, as I mentioned, this argument being made again and again. The FCC, for example, in enforcing its indecency regulation, says that it can look at the context of speech when it's broadcast and say that by determining whether or not the speech is of sufficient merit in its view, whether or not the words being used in that context are protected, or whether they're not. And the very same words may be protected, or they may be the subject of severe penalties, depending on the FCC's determination of the context. There are a number of cases that have recently been decided by the Supreme Court, some that are still pending, that also focus on this notion of whether or not certain kinds of speech fall beneath the dignity of the First Amendment and therefore shouldn't be protected. As a matter of fact, I've been told that for many of the cases that I work on, I have been wasting my career. This from a fairly prominent member of the libertarian community, that I guess I shouldn't probably mention who that is. But the point I want to make tonight and what I want to talk about is that I think that kind of criticism completely misses the point of the First Amendment. First Amendment cases aren't really about the speech. They aren't really about the underlying speech, whether or not it has merit. All First Amendment cases are about the power. Who should have the power to tell individuals what to read, think, believe, or feel? And so regardless of whether or not you think the speech has merit, the merit is in the freedom. And that's what we try and establish in each of the cases that we'll be talking about tonight. I'll explore this theme in some of the cases that I've worked on over the years. Now, first of all, as you heard, John Stagliano is here with us, a true First Amendment hero, someone who I had the great privilege to help defend. This was the case that David mentioned in D.C. last summer, the first obscenity prosecution in D.C. in about 35 years. Now, you might ask, how does the First Amendment and the political values that we cherish in the First Amendment relate to an obscenity trial? And I guess the answer is easily found if you simply go back and read George Orwell's 1984. Keep in mind that the subversive act that made Winston Smith, the protagonist, a target of the state, is that he engaged in a sexual relationship. He had a personal tie that took him away from the state. That, when you really think about it, there's really no more personal connection that we are really thinking about and how individuals define their own sexuality and those choices that they make. And if we give the government the power to criminalize not even the acts, but speech about the acts, then it is an act that is deeply offensive to the First Amendment. Now, again, this trial took place last summer. This was the legal team. I was very privileged to serve as local counsel in a case that involved, I think, some of the finest First Amendment lawyers in the country. Louis Sirkin, Paul Cambria, Al Gelbard, and of course we have John here. Now, at the time this was taken, we were looking a little bit more glum. We'd just been in the midst of jury selection, and so we didn't know what the outcome of the case was going to be at that point. This was taken immediately after the verdict, after Judge Leon threw out the government's case without our having to put on a defense, and so there are a lot more smiles here. This was taken in front of a statue of Blackstone in front of the courthouse in D.C. And so, again, one of the things that was very heartening about that is that even though many of the rulings on motions had been unfavorable, ultimately the important motion to dismiss the case was granted. And also, it was fairly revealing to us that for members of the press that spoke to jurors after the case, the jurors basically said, we would not have convicted him. That if there is a community standard in this country, it is let your neighbor do what he wants. It's not our business. Now this brings up another case where you might wonder where the First Amendment value is. This is the case that was mentioned in the introduction involving a phenomenon called crush videos. If you don't know what they are, I probably shouldn't go into any great detail. Let's just say that they involve women wearing stilettos doing awful things to woodland animals. The law, however, that was adopted went far beyond the issue of crush videos. In 1999, Congress adopted a law to prohibit not the actions, because animal cruelty is already a crime. They adopted a law designed to prohibit depictions of animal cruelty. But the law itself didn't just say we're going to prohibit depictions of animal cruelty. It was written much more broadly than that. It basically said, if you have any depictions of an animal being wounded or killed, and it is illegal essentially in any jurisdiction, then you can be thrown in jail simply for possessing that image with an intent to sell it. Very, very broad language, much more broad than simply saying that you're going to go after fringe sexual fetish films that involve cruelty. Now, we were told at the time, don't worry. We're not going to enforce this law as broadly as the language suggests. We're only going to enforce the law where we really think that there are bad things going on, where there really is some sexual fetish involving cruelty to animals. Had that been the intent, it would have been nice if they'd written the law that way, but they didn't. And instead, we were stuck with this law. But despite the fact that it was passed essentially unanimously by Congress with the notion that we're going to stop crush videos, in 10 years, the law was never enforced. Not a single case was brought against crush videos. And instead, in about 2007, an enterprising federal prosecutor in Pennsylvania who was known for pushing the limits of obscenity law, trying to make it broader and broader, brought a case against Robert Stevens. Now, Stevens is a pit bull enthusiast. He is also quite an expert on the breed. He's written a book called Dogs of Velvet and Steel. Actually, if you go to Amazon.com, you'll find that book, $175. It's about essentially training, breeding, things like that. He is not a dog fighter, interestingly enough, but he also had made some documentaries. Not great production values, but documentaries about pit fighting and also about training dogs for hunting. Now, interestingly, the pit fighting videos were not, they didn't involve fights that he was involved in. He doesn't fight dogs. He didn't even film the fights. They were filmed by others, some of them in Japan where dog fighting is legal, some of them decades earlier. He simply incorporated them into these videos. And so the very first prosecution under this law adopted for crush videos was against Mr. Stevens. 69 years old, a federal SWAT team broke down his door at 5 in the morning, rousted he and his wife out of bed, the wife with a heart condition, and put him on trial. He was convicted. He was sentenced to 37 months in prison, which actually snaps into perspective a little bit when you realize that Michael Vick, who actually was running a dogfighting ring, was sentenced to 23 months. But for putting together images of dogfighting, Mr. Stevens was sentenced to 37 months. The Court of Appeals struck down the conviction on First Amendment grounds, and it went to the United States Supreme Court, where I was, again, privileged to work on that defense team. And interestingly, the argument that the government made in that case in support of the law was one of the most frightening things I've seen in my years as a First Amendment lawyer. They essentially argued that if the government can show that speech is of no value and that it might be harmful, then that speech is not protected by the First Amendment at all. Ultimately, the Supreme Court disagreed, and in an 8-1 decision said that it is protected by the First Amendment. We're not going to create new categories of speech that is excluded from the First Amendment, and described the government's theory as being far-reaching and frightening. Fortunately, a view of the First Amendment that the Roberts Court has continued to uphold in cases after that. That case, I think, is the beginning of a trend that we've seen in cases like this, where the government has made the argument that there are additional categories of speech that shouldn't be protected by the First Amendment. That also came up, again, Gene mentioned it in the introduction, involving funeral protests of the Westboro Baptist Church. The argument was made that their particular message, which is hateful and I think inexplicable, is something that shouldn't be protected by the First Amendment. They provoke all kinds of reactions, and we'll see a few more of those. And that's part of why the speech is protected. They're essentially a family cult. Their view is that all catastrophes that we face, deaths overseas and foreign wars, are God's retribution for America's tolerance of homosexuality. And so they have adopted a number of techniques for their protests, including protesting in the vicinity of military funerals. Now, there's something that is really not known as well about their form of protest, is that they're actually fairly smart about it, in that they call the police in advance, they follow all police directives, they keep the distance from the funeral, and in the case that went to the Supreme Court, they were not even seen by the family, or by the father, who ultimately brought suit, until later he saw some of the signs on television. The popular misconception is that they're disrupting the funeral, and that really wasn't the case. I filed an amicus brief in that case on behalf of the Reporters Committee for Freedom of the Press and 21 other news organizations, including such places as Dow Jones, the New York Times, NPR, and so on, because the underlying rule, First Amendment values that would have been disrupted because of allowing a suit to go forward against these folks would have been devastating to the media and to First Amendment values in general. Now, the argument, again, the government made, and also the amici that supported, I'm sorry, not the government, but the Snyder family made, and actually 46 states filed amicus briefs in support of the family, was that, again, the message that the Westboro Baptist Church brings to us simply isn't worth it and shouldn't be protected by the First Amendment. But again, this misunderstands the marketplace of ideas. So one person's message doesn't define whether or not there's value in a given communication, because after all, the act of communication is two-sided. There's also what is heard and what is believed. Some people will see that and think, maybe so. Most people, I think, the vast majority of people will see that and say, what are these people thinking? How can anyone have these ideas? And that's the marketplace of ideas in action. In addition, there is counter-speech, and as you probably know, the Westboro Baptist Church tends to provoke a lot of counter-speech when they show up anywhere to demonstrate. That is the marketplace of ideas in action. And if you don't believe that, now this isn't real, of course. I just thought it was funny, but there's actually a website out there where you can go on and get this sort of background, and you can add whatever message you want. You know, happy birthday, Mom. I mean, it's just whatever you'd like, and you're sponsored by the Westboro Baptist Church. But again, it is the marketplace of ideas in action. Now, as I say, this kind of argument that we've seen in cases involving such disgusting things as crush videos and silly ideas like those espoused by the Westboro Baptist Church pop up in all kinds of other situations. As some of the people my age in the audience and older will remember, Lenny Bruce was placed on trial for obscenity because of his stand-up act in 3 different states: in California, in Illinois, and in New York. He was convicted in Illinois and in New York. The conviction in Illinois was overturned. The conviction in New York was not, because Lenny died before the conviction could be perfected. George Carlin, similarly, before his troubles with the FCC, was arrested for obscenity at the Wisconsin State Fair. Think about it. Stand-up comics being arrested in this country for word crimes. It simply doesn't sound American. And yet, we have to continue to fight these First Amendment battles because the argument that is made is that this is just trivial speech, it's just jokes, and yet they're saying bad things that the community doesn't like, therefore we should be able to make them criminals. In the case of these, we have one happy ending so far, although, as I say, Lenny was dead, so it's not so happy for him. And we're still fighting the second one. The first one involves a posthumous pardon that we got for Lenny Bruce in 2003. In the state of New York. We petitioned Governor George Pataki for a posthumous pardon, and who would have thought it would happen? He granted it at the end of 2003, basically arguing that it's time to set the record right for First Amendment purposes. This is Kitty Bruce, his daughter, and this is the certificate from Governor Pataki. We were later celebrating was when the authors of the book that led to the pardon effort, Ron Collins and David Scover, and the book is The Trials of Lenny Bruce, great book, go buy it. They won the Hugh Hefner First Amendment Award that year for the book that led to the pardon effort, and that's where I first met Kitty face to face. Although the day of the pardon was a very strange day. It was right before Christmas, and I remember I'd gotten a little bit of warning from the governor's office that it was going to come down, and then the press calls started coming in, and toward the end of the day, I got a call, and a woman on the other end said, I know we haven't met, but I want to thank you for all you've done. My name is Kitty Bruce, and I keep getting calls from reporters, and they ask me what I should tell them about you. And so I said to her, well, tell them I represent living people, too. But anyway, it was quite a celebration, and, you know, while not much help to Lenny Bruce, I think it is helpful to the rest of us to have a state government officially acknowledge 30-some years after the fact that they made a mistake and that trying to prosecute somebody for words that he used, even if they thought they were silly words or worthless words, was a mistake and contrary to the values that we believe in under the First Amendment. The other issue involving George Carlin, of course, is still ongoing. As many of you may know, George Carlin is the stand-up comic, the legendary stand-up comic, whose monologue called Filthy Words, better known as the 7 Dirty Words, led to the FCC revamping and redefining its indecency policy in the mid-1970s. Pacifica Radio had played his monologue, the FCC heard it, and they crafted an entirely new standard for indecency based on the George Carlin monologue. Now, I have to say, I've been studying the First Amendment for a long time. It's the first time I have ever seen a legal standard created by a stand-up comic. And yet, that was the standard that the FCC employed for years, and in many respects still employs, which was odd because for a time I worked at the FCC. I was chief counsel to the chairman and tried to work on indecency cases under him, until finally I went to him one day and said, boss, you know, there's really actually no way we can enforce this law constitutionally. And so fortunately he allowed me to recuse myself from working on the indecency cases and didn't fire me. And so since then I've been out working on cases involving these rules, trying to get them struck down, and preferring to think of the FCC as the defendant. There are, as you may know, a number of cases ongoing, one involving the 2004 broadcast of the Super Bowl, and yes, that case is still going on, the longest 9/16 of a second in history. Second case involving Fox, involving unscripted remarks by Cher and Nicole Richie on the Billboard Music Awards show, and then a case involving NYPD Blue that the Parents Television Council decided was indecent. Now, many of these cases have been going on for years, as I mentioned, and 2 of them have actually been decided by courts of appeals. The United States Court of Appeals for the Second Circuit held that the FCC's indecency policy in the Fox case and in the NYPD Blue case was unconstitutionally vague, that the more the FCC has to say about what it means, the less anybody understands it. And so as a result, it's unconstitutional. The Super Bowl case, we're still waiting. We have one decision from the U.S. Court of Appeals from the Third Circuit where it was struck down. Then after an intervening Supreme Court case, they sent it back to the Third Circuit and said, try over, because the Third Circuit had looked at it on administrative law grounds, and I think next we'll be finding out whether or not the Third Circuit will look at it as a constitutional matter. But meanwhile, these cases continue to go on, and even though we have had these positive steps, these positive decisions, they still continue to take their toll. For example, in 2007, it was the 50th anniversary of the poem Howl being acquitted on obscenity charges. Allen Ginsberg was charged with obscenity because of a public reading of the poem Howl. He was acquitted. 50 years later, because of the FCC rules, stations felt they still couldn't put it on the air because they're nervous about what the FCC might do. Got a little bit of coverage, an editorial from the New York Times and an editorial cartoon. But nonetheless, stations are still nervous. Even 2 weeks ago, for those of you who aren't from Washington, you might not have seen this story, a woman went into the National Gallery of Art and attacked the 112-year-old Gauguin painting, Two Tahitian Women. She said it was an evil painting because it depicted nudity, and because obviously with two women standing there, it had a lesbian theme, and so as a result, she had to do something about it. She tried to rip it from the wall, and fortunately it was covered with plexiglass, so she couldn't do any damage to it, but she beat on the plexiglass with her fists. Now, she also said that she was from the CIA and had radio in her head, so she's now being fitted for a tinfoil hat. But nonetheless, the damage from the First Amendment perspective is, even with an obviously newsworthy story like this, news stations were afraid to cover the episode uncensored. This is what WJLA in Washington did. They had a banner go across the middle of the women's chests so that you would not see breasts or nipples. Fox News blurred out the breasts. Others handled it in different ways. But even with two affirmative Court of Appeals decisions saying that the rules are unconstitutional because they are vague, even with the FCC itself saying that certain times on the news we'll say it's okay, we're just not going to tell you when we're not going to say it's okay. Because of that, stations are nervous because the penalties for violating these FCC rules are really very, very hefty, and they can be, in certain cases, a lose your license kind of violation. There's one more case that's still pending at the Supreme Court, and this may be, oddly enough, one of the most important of them all. This is Schwarzenegger versus the Electronic Merchants Association, a case involving the California law prohibiting the sale or rental of violent video games to young people. The courts of appeals have uniformly struck down these laws as being a violation of the First Amendment. The Supreme Court took it up and has heard argument. We simply haven't heard what the outcome is going to be yet. The reason it's so important is that California is really pushing the envelope and arguing three different things. They're arguing first that violent video games should be a new category of unprotected speech because it's just not important. Secondly, they argue that kids under 18 really don't have any First Amendment rights anyway. And then thirdly, they're arguing that these newfangled technologies shouldn't be protected by the First Amendment. So the underlying principles involving what you would think is a fairly trivial case based on just the subject matter, nonetheless turns out to be really quite important. And we don't know what the court's going to do yet, although based on the oral argument, we're optimistic. Interestingly, during the argument, the Attorney General from California was asked, so, why are you choosing this new area of violence to find a new area of unprotected speech? And his response was, well, we had to start somewhere. So that's the sort of mindset that you get. We'll start there and see what we want to restrict next. And that is ultimately how censorship works. In that case, I filed a brief for the Comic Book Legal Defense Fund, for which I serve as outside general counsel. And we tried to point out to the court that this really is nothing new, that we have seen these kinds of moral panics again and again and again. It was the argument made against the penny theaters and the penny dreadfuls in England in the mid-19th century. Same argument was made against dime novels in this country, against jazz music, against cinema, against comic books in the 50s, against television beginning in the late 50s and early 60s and continuing today, and now against video games. We've seen these moral panics come and go, and the same arguments are being made here. So that's what's happened so far in the cases. Let me just close with something they tell you never to do with PowerPoints, and that's actually to put a bunch of words up there. And I do that because, as a First Amendment lawyer, I think words are important. But more importantly, I think they drive home why the principles involved in these cases involving seemingly trivial speech are some of the most important principles that we've been able to establish in the First Amendment case law. First of all, United States versus Stevens is a case that involves, as I said, images of animal cruelty. What could be important about that? But once again, if you look at the principles that the court finally came down with in an 8-to-1 decision, it really is critically important. The First Amendment's guarantee of free speech does not extend only to categories of speech that survive an ad hoc balancing of relative social costs and benefits. Our Constitution forecloses any attempt to revise that judgment simply on the basis that some speech is not worth it. And in seeming response to President Clinton's "trust me" statement that we're only going to enforce it against the really bad stuff, the court went on to say the First Amendment protects against the government. It does not leave us at the mercy of noblesse oblige. Really critical stuff involving what you would think of as particularly trivial and hateful speech. Snyder versus Phelps, the case involving the Westboro Baptist Church, just decided a number of weeks ago. Again, very hateful speech, really hard to embrace the speaker on this one, and yet the court looks beyond that and says, Westboro's funeral picketing is certainly hurtful and is not, and its contribution to public discourse may be negligible, but we cannot react to that pain by punishing the speaker. As a nation, we have chosen a different course to protect even hurtful speech on public issues to ensure that we do not stifle public debate. Again, following in an earlier precedent involving Jerry Falwell and Hustler magazine, finding that even hateful speech should be protected. Fox Television, the case involving indecency. And again, this case arose from Cher and Nicole Richie making unscripted remarks at the Billboard Music Awards show. Hard to find much political content there. And yet, the principle is that the government just doesn't get to make up the rules and then let everybody guess at what they mean. The court writes, the FCC assures us that it will bend over backwards to protect editorial judgment, at least in the news context, but such assurances are not sufficient. Instead, the FCC should bend over backwards to create a standard that gives broadcasters the notice that is required by the First Amendment. And then finally, a case that I haven't talked about tonight, but that I think establishes these principles. This is a case I argued at the Supreme Court about 10 years ago involving, believe it or not, the phenomenon of signal bleed. Signal bleed meaning random images of unscrambled cable that can somehow be discerned a little bit. It's also been called Picasso porn. And as part of the Telecommunications Act a number of years ago, heavy regulations were placed on adult cable networks, and particularly Playboy Television. The court, in a 5-4 decision, said that we cannot be influenced by the perception that the regulation in question is not a major one because the speech is not very important. The history of the law of free expression is one of vindication in cases involving speech that many citizens find shabby, offensive, or even ugly. And finally, don't bother to try and read this next one, you'll go blind. There's a lot of words here, but this is the reason I'm a First Amendment lawyer. This was in the majority opinion in Playboy. Justice Kennedy wrote this for the court. When a student first encounters our free speech jurisprudence, he or she might think that it is influenced by the philosophy that one idea is as good as any other, and that in art and literature, objective standards of style, taste, decorum, beauty, and aesthetics are deemed by the Constitution to be inappropriate, indeed unattainable. Quite the opposite is true. The Constitution no more enforces a relativistic philosophy of moral nihilism than it does any other point of view. The Constitution exists precisely so that opinions and judgments, including aesthetic and moral judgments about art and literature, can be formed, tested, and expressed. What the Constitution says is that these judgments are for the individual to make, not for the government to decree, even with the mandate or approval of a majority. To me, you can find no better statement of what the First Amendment is about. And I can tell you from the standpoint of having fought that case for a number of years and finally argued in the Supreme Court, there is no more humbling experience than to see the work that you have done end up on a page with words like that. And for that reason, I feel like the work that I do every day is a great privilege. Thank you.